they have to bring certain things that will be helpful for them to retain that position, which meant that would violate someone else's rights. That means Supreme Court will chime in and it will try to cancel out. So to prevent all this, they created this 9th schedule. That is, 9th schedule was considered as a blanket immunity. Ninth schedule was intended, use that exact same word. 9th schedule was intended, that is, it was originally thought of as blanket immunity. Clear up until here? That is an important keyword. You have to use this exact same word, blanket immunity. Intended blanket immunity. Fine. Now, see, these three cases. Golaknath case was a state of Punjab, Keshwanand Bharti case was a state of Kerala, Indira Gandhi versus Raj Narain case. This is triplet case in which all three pay. Your judiciary tries to maintain the checks and balances and gains more power. By gains more power, Supreme Court today, what it is, was completely formed in these three triplet cases. These triplet cases, we are using the word triplet cases because one gives power to the other. Understanding? In each one of these stages, ultimate end landmark is your basic structure of constitution, or basically the power that Article 13 today wields. Write that in your own words. See, if a particular government has to still come back for the next term, then it has to introduce populist schemes. Okay, meaning they have to choose a certain section of audience, give them advantages, so they will choose this person again for the next time. That is your entire concept of your caste politics. So in your Golaknath case was a state of Punjab. Okay, let's not enter into complete details of the case, but I'll tell you the gist of it. In this period of time, your legislature, okay, I told you, legislature, executive, judiciary. These two were trying to make sure they amass huge amount of power. Okay, which means cut this guy by telling, blanket immunity, this guy cannot even peek into what is there inside that, or whatever is there in this. You, even if it is wrong, nullify, you cannot enter into this. So it is nothing but they are trying to curb this guy ka power, which means they are trying to overpower. In this case, they told, this legislative and executive kept telling, this pay I put law, then you can't find it. For example, this, 31C, right? When Article 14, okay? When Article 13C comes in, Article 14 will go out, the concept of equality. Here is where basically this reservation and all these things started. So somewhere they said, we are going to introduce DPSP, which means certain people's fundamental right will be violated. We can't do anything for that, this, all the stories they kept telling. The first instance, your Supreme Court, okay, tried to bring in the concept of certain set of power by telling, in the Golaknath case, Okay, fine. Legislature will make laws. Whatever laws, let it be. Let it be normal laws or in the immunity laws or anything you put in. But we will check if this law is violative of fundamental right. Okay. Let's say constitution has so many features. Okay. Your fundamental right is only from 14 to 32. Again, the time frame I'm telling is back in 1970s. All right. Where people are just trying to make sure they will remain in power. They will be having most of the power in their hands. Amidst all the spaces, Supreme Court had to slowly start chipping its place for itself. Supreme Court at this period of time tells, okay, fine. You're telling I have no say in what the law is also. Let's say legislative and executive have brought a law. They have told that Supreme Court cannot interfere at all. Yes. In the Golaknath case, they tell, no, okay, fine, you place a law. Okay. Of all the articles in the constitution, if this law is violative of just these articles, then I will declare them as null and void. Meaning, Article 13, that is judicial review, will be utilized if the fundamental rights are violated only. If any other article were violated, okay, fine, we'll just keep quiet. But if it is just this, then we will declare it null and void. Meaning, judicial review started taking the first step. Understanding? Now, when I tell this, by the time of 1970, okay, your Indira Gandhi had come to power. Constitution was almost treated, again, this is very informally speaking, it was treated like a toy. Anything and everything she wanted would happen and could happen. So, this was the first stage they took at this point. That is, Golaknath case was the state of Punjab. The verdict was, if the law is violative of the fundamental right, that is the amending procedure, we have something called amendment, changes if you have to do in the constitution. If any changes you're doing in the constitution, it is only through Article 368. Okay, Article 368 is the amending constitution. If any amendment done in the constitution is violative of fundamental rights, then we will declare it null and void. Clear up until here? So this was the first step. Write down about this. Clear up until here, right? This is the Golaknath case. As in time progressed, 1970, we approach to the next incoming war. Okay. India had to enter into your Indo-Pak war or Bangla war. Okay. At the same point of time, our population was rising with repeatedly. Okay, like hellbounds was there. There was no ups and downs to the amount of population that was growing. And also the world had entered complete Cold War era. Okay, 1945 war ended. But when we say after that it entered Cold War era, But if you look at it, 1970 is where the world ended, complete Cold War era. Okay, I have the teaching detail. So we entered complete Cold War era, which meant the world is now more at high stake tension than ever before in history. Amidst all this time, we have one prime minister who comes in, Indira Gandhi. Now again, informally speaking, complete dictatorial rule. No person could say anything. At the same point of time, we also had, amidst these things, we also had another thing, that is your Khalistan movement, or wanting for the formation of Khalistan. Pro-Khalistan supporters were trying to harm the internal security. So we had security threat from outside of India, from inside of India, population measure, world organizations completely, your WTO, IMF, World Bank, everyone was pelting us. And then world entered into this complete Cold War era, meaning USA is forcing us to join sites, USSR is forcing us to join sites. Up on the same time, we entered into this war era. That is with our neighbor, that is your Bangladesh war. To control all this, she invoked this concept of emergency. Now, in this emergency, the amendments that were made were so much so that your 42nd amendment is called as mini constitution. So much so that our new constitution itself could be created. Anything and everything. For example, your fundamental duty was added, your preamble was changed. Every single thing, whether it is justiciable or non-justiciable, but amendment. Anything that didn't serve our purpose, amended. Anything that is coming as an obstacle in my course, amended. Okay, so much so that the amendments were going way out and beyond. Okay, this is the same time Supreme Court came with this. The case was different. We have discussed this case earlier in the class. See, the Kerala pe, this person ka land that Kerala authorities were trying to take away. But Supreme Court turned it into an international thing. By international thing, next one pe you will understand how it's an international thing. But Supreme Court turned this small case into the landmark judgment it is. This is the highest judge body, 13 judge body it was. Meaning, we have 3 judge bench, 5 judge bench. Up until now, the highest judge bench that any case has ever had is this case. Keshwanand Bhatt is 13 judge bench. The verdict was 7:6. Read on up until here. Done. See, on these 3 cases, they were about the issue that particular person or particular party had against a particular state. Golaknath case was against your Punjab, Keshwanand Bharti case against Kerala. But Supreme Court turned all these 3 into a national importance. All these 3 speak about one thing. Amendment power of your legislature. Write that down. All three core crux, if you have to tell what is all this we're talking about, is amendment powers of your parliament or legislature. Okay. So when I said it is a 13 bench body, they were deciding on this one simple concept. What is the amending power of the parliament? What limits does that have? 7 members voted that yes, legislature can change or amend whatever they want in the constitution. 6 members were against, no, your parliament cannot amend whatever it wants. Because of one vote, this 7-member body, 5 votes when it won was, the judgment is this. Parliament can amend anything and everything in the constitution. But this is where these people introduce this term. First part of the verdict, listen properly. Parliament can amend anything and everything in the constitution. But as long as it does not affect the basic structure of the constitution. Done? Your legislature and parliament were happy with the first part of the verdict. Parliament can amend anything and everything that is a part of the constitution. The second part is what they misjudged. As long as it does not affect the basic structure of the constitution. Okay. They will come, okay, some basic structure. Because at that point of time and still today, this concept is not defined. Supreme Court has not told what constitutes basic structure. Now what happened? They felt like the parliament felt like I have the upper hand. I can amend anything and everything in the constitution. Emergency was coming to an end. Your elections were to be held. Okay. Your elections were to be held and the atrocities that were created in the name of amendments had to be brought into court. But again, just fresh out of Keshwanand Bharti case. What did it say? Parliament can amend anything and everything. So the Prime Minister then amended that election of president, election of Prime Minister, election of members to your legislative assemblies or basically your Lok Sabha. Election of president, election of prime minister, election of members to Lok Sabha during the emergency period of time and all this period of time where whatever happens and however it happens in your constitution, how the election for each of them should be done is also given. They have brought in an amendment because if they told na Keshwanand Bharti case anything and everything they can amend. Okay. So according to that, they passed an amendment. Election of president, election of prime minister, election of members to Lok Sabha, and all these things are outside the purview of judicial review. Meaning, even if there was malice, even if there was fraud, even if there was, okay, all kind of things that we do not associate with election is to be involved also, your judiciary cannot be involved. Amendment to anything, Keshwanand Bharti case told, na, you can amend anything you want. This is all these things are part of your constitution only. So your parliament can amend it. This is what they tried to bring it. Okay, this amendment was also brought in. As soon as they brought in, this was opened. Indira Gandhi versus Raj Narayan case in 1980, which held, yes, you can amend anything and everything in the constitution, but as long as it does not affect the basic structure, they told the election to President, Prime Minister, Lok Sabha, federal system basically is the core concept of basic structure, meaning you cannot amend that. Why? Because it is forming the basic structure. This is how, this was in the 1980 case they brought in, because this was going to be the one which was Indira Gandhi could not complete the elections because of this. A person of that might, that power, at that point of time, complete dictatorial control, all the power was in her hands, and this power was destroyed by this. Meaning, judiciary took power, control, and gave Article 13 the utmost power that it has today is because of all these three cases. Remember, I told the ninth schedule case where Jawaharlal Nehru had brought in that concept. They even revisited that judgment. Supreme Court, not just Supreme Court, our Indian judiciary are self-corrective, meaning whatever judgment they would have once passed. Let's say a three-member judge body told that, okay, ninth schedule means we also can't change it. Now, this decision can be overpowered by a larger bench. Now, five-member body came in and told, no, we will, this ninth schedule cannot be considered as blanket immunity. We will still check that also. So now presently, ninth schedule does not have blanket immunity and it is applicable for judicial review. The outcomes of the triplet case, meaning anything in the constitution is now all up to your judicial review. There is not a single thing that you can keep outside the purview of judiciary. This is how judiciary sculpted the so-called basic structure of constitution. Understood? Understood? Yes, no, something?
of basic structure of institution? It was first introduced in Jayanagara case, or it was there before?
Jayanagara case.
Why wasn't Indira Gandhi allowed to contest in elections?
And that story is big, but she used a public official for political campaign.
Not because the case was.
The case was going on, but she could be removed or she couldn't contest the election on stronger grounds. Was the case, you can keep on putting on appeals. Okay, instant you will not get. But one of the strongest reason for her to be removed from contesting election was she used a public official in political campaign. That is strictly forbidden in Indian Constitution. Then, in the Indira Gandhi versus Raj Narayan case, they upheld that federalism is the very core concept of Indian Constitution and is a basic structure, which meant federalism means concept of center state. Okay, they converted it like this. Prime Minister is for the whole country. Is the Prime Minister for both center as well as state? So which means the elections of the Prime Minister, President or to Lok Sabha, all these three are crucial elements of your federalism, meaning if this is a part of basic structure, then these are also part of basic structure. So through this, your Article 368 amendment power of the Parliament, okay, was further concentrated, that is circled from all sides by your judiciary, strengthening the concept of judicial review. Article 30 versus Article 368. These kind of things are not there in your books or in any sources, but when you use these kind of things and underline it, this is good for you to earn brownie points. Clear up until here, any doubts? Anything you don't understand? Okay. So the next topic that we enter is federalism. Then, see, one of the common mistakes for students to commit is confuse federalism with federation. Both are not equal. Article 1 states that India is a union of states and not a federation. Meaning, federation, again, we've discussed that in very large detail. States coming together to form a union or a country is called federation. Understanding? Like your United States. The 13 colonies came together and created one union called as United States of America. The United States, meaning all the states came united and formed a country called America. India पे no such thing took place. First, India concept was formed and then all the states were integrated. So, we are a union of state and not federation. This word is nowhere used in our constitution. The reason being, when states come together to form a union, which means they have a right to leave and go, which means they have a right to cede in a federation. Whereas India पे no such rights is there because no such states came together. That is why no states have right to cede in India or in union of states. That is why we have indestructible union of destructible states. Write down the history of federation. This federation and federalism is not same, totally different concepts. But most of the time, students get confused here. Word federation is nowhere mentioned in the constitution. India is not a federation. So up until I'm not yet discussed what federalism is, but is federalism a part of basic structure? A very much core concept of basic structure. Write that down. Done? This is a very simple topic, easier to understand, but very much the place where students lose marks in prelims. Understand this topic very well. I'll use examples. You also write down in that form. Opposite of federalism is unitary form of government. I write that down. Federalism in layman terms is this simple. Center, state. Understanding? India is federalism, yes or no? We have state governments, we have central government. So this was the UPSC prelims question. Statement form of questions. I'll ask the same thing back. Regional governments are not present in unitary form of government, yes or no? I'll repeat it. Regional governments are not there or states are not there in unitary form of government. Answer was false. See, that is where I'll try to explain it. Write it down like a story when we discuss it like one. Unitary government. Okay, before everything, understand this. Let's say this country is China. Okay, this country is India. Okay, now China pe all the power, everything is rooted in this People Republic of China. This is one party. Okay, don't get into this understanding. These people are the ones who will dictate what will happen in this country. Understanding? पूरा country के लिए whatever is to happen, these people only will dictate. Understanding? Consider them as either national or center. Okay? The central government is this party. Okay? They are only legislature, they are only executive, they are only everything. Whatever they tell, that only will happen in Pura of this country. Understanding? This fellow is as greedy as he comes. Any people ka, any state you tell, this fellow tells it's mine. South China Sea, it's mine. Arunachal Pradesh, it's mine. Accession, it's mine. Tibet, it's mine. That particular means his all here. Some other this only. Okay. And eventually it becomes his country only. That is your case of your Tibet. Okay. Taiwan. Again, you will learn all this in international affairs. Something that's not even connected to mainland. Mainland means this area. For that matter, even India pay, Northeast is not completely connected with our mainland. In between, we have Bangladesh. Yes, no, something. Why am I getting blank faces? I'm telling completely it's not connected like the mainland. See, now when I say mainland, all of this is fully connected. Yes. But whereas here we get another country. Yes. And then we have another portion of India. Understanding? We have a country between our countries. Similarly, this China guy has this all over his Southeast Asia region. Okay. Now understand this. Now this guy, to make his administration easier, he creates one government here. State government. Okay. He creates one state government here. Because it's easy to administer. Inside this country also, he creates respective state governments. Why? Because it's easier to administer for him. Okay. Who created these state governments? This guy. This guy is a party. Let's consider this guy as the main or center. Let's assume this guy has one constitution. It's a big joke, but still, example purpose ke liye, this constitution is there. Tomorrow, this guy wakes up and decides, I'm going to remove all these state governments. And just all the state governments will be removed and one block. Understanding? All that is just union. So here the states were created by whom? This party or center. Now the states were destroyed by whom? Center. So the existence of states are not by the constitution but by the center. Okay, meaning they are in destructible nature. Any day they can go off. Understanding? Now, just okay, write down up until here. With the example you write down, I'll tell you why it's useful. Or in a way that you easily understand, write it down like that. The statement, federation is a part of basic structure. True or false? False on all levels, okay? Federation is not a part of basic structure. Federalism is a part of basic structure. Or both those statements write down, so you will not get confused. Done? So accordingly, the existence of states are determined by the center. Okay, state will exist or not exist is defined and determined by the center in unitary form of government. Understood? That doesn't mean states will not at all exist in unitary government. Yes, they may exist or they may not exist. But if they exist, that is because of center's determination. Is this clear? Write that exact line down. Center in a unitary form of government, states may exist or may not exist. If they exist, it is because of center. If they are removed, that is also because of center. Clear up until here? Yeah. India scenario. Our constitution is probably one of the most elaborate constitutions in the world. It has told, like I told you, how the election for president should be, how the election of parliament members should be, how election of prime minister should be. Everything is mentioned in detail. And same thing, it has also mentioned the nature of Indian polity, that is federalism, meaning your Indian constitution has told there will be a center and there will be states. Okay, understand this? There will be center, there will be states. We have to get a doubt here. We just said in Article 1, India is indestructible union of destructible states. Yes, meaning state can be kept on destroying. Here I'm telling constitution has told center also should be there, states also should be there. But this constitution has not mentioned how many states should be there. Meaning from 10 states, I can create 31 states. From 31 states, I can form them or club them together and lead them to 6 states. Okay. Create how many ever states you want. But concept of states should be there. Understanding? So this states, tomorrow morning, if center wakes up and decides, I will remove all states and just make it one union, like how China thought, it cannot do that. Because the power to become state or the power for existence of state was not given by center, it was given by constitution. Understanding? So if constitution gave this power, constitution only can take away its power. By constitution only giving power, constitution only taking away power means parliament can basically amend it. That is what was your Article 368. Basically, that's what Indira Gandhi tried to do in 1980. Remove the election process of Prime Minister, President, Lok Sabha, everything can be altered, meaning she can change up the concept of state itself. This is where your, again, 17, your Keshwanand Bharti case will come into picture. Parliament can amend anything and everything in the constitution except the basic structure. And this is a basic structure, meaning center or even if your parliament decides to amend the constitution to remove the concept of state, it cannot remove the concept of states. Why? Because it is the basic structure and also the existence of state is given by constitution and not by center. So center cannot destroy states. But what it can do is it can integrate and disintegrate states, meaning club two states together or break one state into two states. Understanding? Write this down. Done clear up until here? Any doubts? So, in a federalism state, can center destroy the concept of state itself? Now see the striking features between unitary form of government and federal form of government. Okay. Here, constitution may exist or may not exist. Not an issue. Okay. They don't have any issue. But for a federalism means what? Simple words. That's it. Center, state. Okay. Now, if the state has to be there and that should not be decided by center, then constitution has to be there. So, constitution has to be there mandatorily. Understanding? Now, here constitution existence itself is a doubt whether it could be there or it could not be there. Let's say if this constitution exists, okay, if this constitution exists, it could either be rigid, like let's say your France, okay, or it could be flexible, like your Britain. Meaning, if this constitution is there, okay, and in the constitution, let's say they've spoken about state, okay, state has to be there. And if it is in the parliament, just if some 10 members out of 500 members are getting up and telling no longer state is needed, then it can be amended, means then any person can change that concept. So if it is easily changeable, it's called flexible. If it is very difficult to change, if the amendment procedure is very difficult, then it is rigid. If you see in the list of world, one of the most rigid constitution is France and your USA. Very flexible constitution is Britain. Okay. Whereas with respect to federalism, okay, it has to be rigid. If it is very easy to change, then anyone can change. So constitution has to be rigid. Understanding? Now, in the unitary cases, constitution could be either written or unwritten. Written like India, South Africa, all these things. Unwritten, again Britain. They have portions of the constitution that are not at all written, which means they follow it by your protocols or procedure. But whereas if it is unwritten, then center will tell, where it's not written anywhere. I can't give you any more power. It can't have that bargaining chip. For that reason, constitution should be written in a federalism. Done? Next, the so-called existing constitution. Yes, it may not exist. It's rigid, flexible, it's written, unwritten. If all that, if you see the supremacy of the constitution, okay, it could either be supreme. Constitution could be either supreme one of the places the constitution is supreme is in the case of Japan. Or it will not be supreme in the case of Britain, because Britain has parliamentary sovereignty, which means parliament comes before your constitution. Understanding? So here Britain gives more priority to its parliament than constitution. Here parliament or anything else, but constitution has to be supreme. Okay. The next we are going to discuss was a prelims question. There is no division of power in unitary form of government. No, don't write that down. This is a question in prelims it was asked. Division of power means पूरा India के लिए some power is there. That is divided into center and state. Yes. The prelims question was this. In unitary form of government, there is no division of power. Yes or no? It's a statement kind of question. Think. In unitary form of government, there is no division of power. Yes or no? There is no right answer, no wrong answer. I mean, there is a right answer, but you don't have to worry about it. What do you think? There is. Okay. Division of power. See, for division of power means then state has to be there. In your unitary form of government, state are present or absent? Can be, right? State can be present or state cannot be present. If state is present, the whole point is they're giving us because they are giving some autonomy, or it will be easier for administrative purpose. So division of power also can be given or cannot be given. See, cannot be is also there, can is also there, which means we cannot tell, no, there is no division of power at all. So division of power can be present or cannot be present. Division of power may be there or may not be there. To answer the prelims question, is division of power there in unitary? Yes, it is there, but this is given by your center, which means this will be taken away by center. Write both those. Done? Here, what is the case? Division of power. It has to be there and it must be there. And the division of power pair, this power is given to center by whom? But to state. Constitution. The power to the states are given by the constitution and not by the center. Write it, highlight it. Very important. None? See, the power is given to the states by the constitution. Yes, and it should be written. Otherwise, center will keep on dominating, telling no, it was not written anywhere. So the power that is given to the states by the constitution, this demarcation came to India in the name of lists. Okay, these lists are present in your 7th schedule of the constitution, meaning central list, state list, concurrent list. There are certain subjects in which only center will make law, like defense, okay, like for example international banking and all those things. There are certain subjects in which only state will make law, for example agriculture, police, okay. There are certain subjects in which both center and state both will make law, for example postal, okay, information services. Clear? So this is present in the constitution. The lists are present in the constitution, which means the original intended constitution itself they have put. Because of that feature, your Supreme Court was able to prove that no, this is the very basic feature of our constitution, which means your parliament using Article 368 cannot amend these things. But whereas, let's say some subjects in the center can be transferred to state, some subjects in the concurrent list can be transferred back to state list. The subjects can be transferred, but on the whole, they cannot remove the concept of state or center or concurrent, any such things. Understanding? Head on up until here. 7th schedule important. You have to by heart that. Done? Because we are on the topic of list, we'll see the order of precedence. Write that down as a subheading. Order of precedence in lists. Okay. Whenever a law is made, okay, central list takes priority over state list. Write that down. Understanding? What do I mean by this? Let's say a law is made. Okay. This is a very generalized common law. Let's say helmets, compulsory mandatory wearing of helmets. In the state पे on helmet wearing के लिए state told if you don't wear a helmet in the night time, it's fine. Daytime पे it's mandatory. That is the state law. Now center makes a law on the same subject. Okay, telling helmet wearing, same subject pe only this I'm telling. Helmet wearing is mandatory for both daytime as well as nighttime. If this is the rule. Now, common people will get confused. Which law should we follow? State law or central law? For this ke liye, Constitution itself has given the solution also. If a law is made on the same subject by both center and state, then central law will prevail. So in this case, even though state has made a law that night time you don't have to wear a helmet, but because center has made a law on the same subject, which tells both day and night you have to mandatorily wear, this becomes the priority and this will be the function. This is what people will follow, have to follow. Why? Because same subject if center and state makes a law, central law will prevail. I'm not telling of these three lists, central list is top. Not like that. Do not understand it like that. On the law made by both on the same subject, central list will prevail over state law. Clear? Now, when it is between central law and concurrent law, that is a subject, whatever topic which is there in each of this, we call them as subject. A subject which is there, okay, and center also makes a law, and both here concurrent list pe whatever subject is there, which means both state can also make a law, center can also make a law. In that also, if you see the law, center will prevail over concurrent list. Write that down. Okay. Now, whatever subjects that are not there in any of these three lists, okay, it may come in the future. Okay, any other topic of importance, for example, now your privacy and all these things. Back in 1950, that was not the issue. So it was not added in any of the lists. So any of those subjects which are not added in any of these lists will be called as residuary subjects. And only center can legislate in this, which means only center can make laws. Done?
Some of the subjects are common in state as well as federal. We can
Concurrent.
like if I handle this, in your thing, you become the laws are made of the same subject, then the priority is with the center. So these are some subjects which are common in center as well as state, where both like state government and center are making law.
And that is why it's called concurrent. This section pair, both center and state, both can make laws. What? Yes, that could be in any of the cases. For example, say it could be in the central list also, or it could be in the state list also. But if there is a law that becomes very common that it has to be made. Okay, so you are asking what if a state law is there in both center and state? Yes.
The law will be Supreme.
By the center. What I tell is in these conditions that we still have further to discuss, but still, just as an example, I'll let you know. Agriculture is a state list. I told you that, right? But there are certain conditions, okay, in time. For example, during emergency precedence rule and all those things, this subject, whatever is there in state list, center can make laws in the state list. At the same point of time, state also can make laws on that. Understanding? Agriculture is actually just a state subject. That's it. It's there in the state subject. But there are certain conditions. What those conditions are, further down we will see on a separate topic. On those conditions, center can laws on all the state topics. But at the same point of time, state also can make laws on the same subject. In this point of time, when there is a conflict, then this will prevail. Understood? Clear up until here? So now, based on all this, is India unitary or federalism? Okay. If India is to be called federalism, then it has to, we saw the 4 points where it was like completely federalism. But India is a mix of unitary and federalism. But if you say, is it unitary or federalism? It's federalism with unitary features. That's what you have to write. India is federalism with unitary features. Okay. For a federalism polity country, what are those unitary features? First and foremost, single citizenship. Now, in proper federalism countries, if you look like USA, USA is a proper federalism. There is clear differentiation of center and state, where they have dual citizenship. Citizenship of the state as well as of the center. But India, there is only one citizenship, that is single citizenship. This is a feature of unitary government. And we have a single constitution. In a federation, again, they have one central and one state ka. But India, there is only single constitution, there is only single citizenship. Okay? Another thing, this irritates states the most. Emergency conditions. Whenever any sort of emergency is imposed, center becomes extremely strong. Makes states very weak, meaning all the powers of states are taken off by the center. You asked now previously, what are this is one other condition, okay, where, yes, during this emergency, again, center-state relations, we have multiple more cases, but in these scenarios, all the subjects in the state list, whatever is there, center can make law. State also can make law, but center can make law. At that point of time, whenever conflict is there, then only center will prevail. Understanding? Let's say in a concurrent list, I told you concurrent list means both center and state can make law, right? Now, in a concurrent list also, when a law is made and when there is a fight between center and state, center only will prevail. Okay, this list ka thing again irritates the states most. Understanding? Another thing. Finance. See, we have something called Finance Commission. Okay. Your center only will constitute it at the end of every 5 years. That is also a separate topic. We'll deal with it. But your states have to depend on the center for money. Yes, in the state, they can tax and everything. But some taxes, the state, whatever it collects in its state, the center will take it off. One common thing is income tax. You are in this state, you are working in this state, your revenue is coming to this state, then the money should go to this state. No, but center will take off that money. Okay. One other thing, the center hates the most. I mean, states hate it the most. All India services, they don't, it's not that I'm telling they hate these people, they hate the control of these people. This, okay, all India services, that is your IAS, IPS, IFS, you work in the state, but you are under the control of center. So you are answerable to the center. Disciplinary actions are temporary. If someone from this sector is doing something, the state cannot take any actions against them. State cannot dismiss them. State cannot remove them. Only center has the power to do that. And more specifically, president. Understanding? One more thing is our judiciary. We are an independent integrated judiciary, meaning there is no separate judiciary for center, there is no separate judiciary for state. When you are a federalistic or a federalism polity country, you want a judiciary for state and a judiciary for center, but ours is an independent and integrated judiciary. Okay. Center is there. State is there. Center should do its work, state should do its work. Election for center happens separately, election for state happens separately. This is fine, no? But no, center will not leave it here. Center introduces this concept of governor for the state. He acts more like an agent to the center. Let's say the state legislative assembly they'll pass a bill, okay, to get the chief minister and everything. They have won through the election of people and everything. They'll get a bill thinking to pass. Now, when they give it to this guy to sign, okay, he can either give the sign or he can reject the bill and all those, fine up until here. But this guy has one more feature. No, I'm going to reserve this bill for the president. Okay. This angers a lot of current affairs also. It will be many a times you can see. All the time there will be tiff between governor and your state governments. They're telling, we have won through the election. We know what the state wants. We are doing all these things. And with so much difficulty, we passed the bill and you either sign it or reject it. Fine. But you're telling you will withhold it for the president. Now that is where here is the next portion. The president will do only what the COM will tell. COM is nothing but your prime minister and council of ministers collectively. So it is directly, in a way, your center is controlling the state. This irritates the states. The concept of office of governor. They are telling, why do we need that? We are doing our work. Why are you simply unnecessarily coming and poking your nose in everything? Okay. The next is election commission. We have only one election commission. Don't get confused with state election commission. State election commission conducts election for panchayats and municipalities only, not state assemblies. Your state legislative assemblies also election is conducted by your election commission of India only. These people are like, why we will only do it? They're like, nope, we will only do that also for you. So state election commission is also only one in our country. Another thing, audit mechanism. States work so hard to generate income for the states to make sure they'll get more money and everything, but they can't even audit their own finances. That also center only will tell how and who should audit. States have no role or say in anything. States have no role in even the money that is coming into states. This was the recent current affair where Karnataka government was complaining. The money, assume it like this, just not any particular state, just to understand this, I'll tell you. This is state A. Okay. The state A is making so much money. Let's say the state is making 3,000 rupees income. Just example. 3,000 rupees of income is coming to this state from this activities of this state. So the state A should be happy, thinking, yes, I have this much money, but all this 3,000 rupees is taken off by the center guy and he gives him 30 rupees. This is what happens in our system. This angers him the most and he has to keep begging, hey, at least 30 rupees is not enough, give 50 rupees at least. This is the fight. They're telling our state is generating this much income, you take that away and you give us this. Where are you putting the rest? In states which are not even performing. Where states are performing, let's say in this state, it is getting, okay, the overall income the state is making is 50 rupees. And you are giving him 2,000 rupees. Okay, so this is where the states are complaining that states do not have equal powers. So now can you say India is federalism completely? So India is a federalism with unitary features. Understanding? So there are multiple thinkers who have given their concept on how they view this version of federalism. Just write those down. You can use it for mains conclusions. Okay, these are all thinkers and what they have told about India's federalism. First one, K.C. Weir. K.C. Weir describes Indian constitution as quasi-federal, underline quasi-federal. Okay. Next one, Morris Jones calls India's federalism as bargaining federalism. Okay. Next, write down Ivor Jennings. Ivor Jennings calls Indian federalism as, put it in quotes, federation with a strong centralized tendency. Okay. So people